pistä tallennuksen päälle. Nyt pitäisi olla päällä. Okay, today we have Professor Jaakko Husa from the University of Helsinki, and he has promised to talk about comparative law and comparative law methods. And we will discuss the topic first generally, and then we will go to some IP law specific questions. Jaakko is not a specialist in IP law, but he has general knowledge about comparative law, so we will discuss this from these perspectives. And first, I would like to give the floor to Jaakko to introduce yourself more properly. So, what type of research you have done, for example?
Right, thanks. At this moment, my chair is called Law and Globalization, and previously I've held several chairs in law, ranging from public law to jurisprudence and from legal culture to legal linguistics. What I'm doing now is really something that I want to do as a researcher. It's comparative law in a broad sense. I'm very much interested in the method and theory of comparative law, but also comparative legal history, comparative legal linguistics, and also comparative constitutional studies. And at this moment, I'm finalizing a book that will come out in next May. It will be published by Edward Elgar Publishing. The book is titled as Interdisciplinary Comparative Law. And I'm also at this moment co-editing a third edition of Elgar Encyclopedia of Comparative Law. And that's going to come out in several volumes in 2023. Besides those, I'm also interested in law and globalization as looked from the point of view of so-called global comparative law. And beyond those things, I also have interest in Chinese law as seen through the Hong Kong legal system that is really living sort of a period of transformation at this moment.
Thank you. Looking forward to your future publications. Okay, this brings us to some basic questions about comparative law. So what is comparative law overall, and are there different schools of thought, for example, what it is or what it ought to be?
Well, I think that there are really different understandings of what comparative law is, or what comparative law should be, or what it should not be. But in general, I'd say comparative law, or you can also call it comparative legal studies, which is a slightly broader term, is really about studying different systems, their similarities, their differences, and then trying to understand and explain why there are these similarities and differences. So it's a very broad area of research. However, the thing is that there are lots of different understandings of what it should be, what it can be. And at this moment, if I'm very sort of a very general view, could be possible that there are two schools of thought, very broadly speaking. One school is this sort of a traditional school that is interested in law in books, in a sense that law, black letter law, legal doctrine, legislation, and case law. Then the other kind of approach, or bundle of approaches rather, is interested in law against its context, law in context, or this cultural view of law. And there's lots of things going in between these two extremes, but you could say that there's this sort of a rule-oriented, sort of a traditional comparative law, and then this more recent contextual comparative law. Those would be probably the main schools of thought today that we have.
Okay, so what does comparative law or comparative law methods, what do they offer when compared to other methods, for example, legal dogmatics?
Yeah, I think that it would be a good idea to see comparative law as a part of a bigger whole, which would be comparative or legal studies in general, law as an academic subject. You can have doctrinal approach, historical, sociological, various approaches are there. And it's useful to see that comparative law is just one of those approaches. And what it can offer is, I think there are two kind of main things that it can actually offer. One thing is for practicing lawyer, for practical persons, it offers you a new way of looking, perhaps even your own system, seeing your own system in foreign eyes. And that is very useful. You can see that, okay, I have never thought about those questions. That, oh, all right, it can be like otherwise. You can see it from the outside. And that is a learning experience. You look over the borders. And the second thing would probably be that I think that this is sort of a more demanding, more ambitious way is to, it provides you some kind of overall picture of how law and these human communities, how they interact. You can see that in Asia, in America, in Europe, that it takes different forms. There are lots of similarities, of course, but also you can see how similar type of questions are being approached or solved in different ways, perhaps. And it gives you in that way sort of a deeper understanding of what this thing that we're interested in, law, actually is. But it's only one part of it, and it needs also this historical, doctrinal, theoretical, and other views to law. But it's one member of the family of legal sciences, so to speak.
So it sounds like the functional comparative law method, which I used to study when I was a basic student. I think it was Weigert and Kötz's textbook on comparative law. So it's not the only alternative. Is it still mainstream functional? And what is functional comparative method? Could you maybe illuminate it?
Basically, if you look at Weigert and Kötz, I think that they based their own work on earlier work of Ernst Rabel, who's expert in private international law, conflict of laws, if you like. And I think that Rabel's sort of a key idea was that comparatists find this surface of law, language, legislation, and case law. And he realized that that may not be enough. So you have to make different kind of questions. And his idea was simply that law and legal rules have some kind of social functions. And Weigert and Kötz based their own approach on that. Obviously, it's important to realize that it's not just one functional approach. There are many. There are problem functionalism, sort of a structural functionalism. It's a bit different thing to do problem-based functionalism. But I think that the basic idea is that you don't trust the text that you're reading. You don't think that piece of legislation actually tells you how that system actually works. And you have to make some kind of deeper question that what is the social function of say, contract law? What is the function of criminal law? What is the function of marriage law? And so on and so forth. You make these different kind of questions. And today, I'd say that perhaps it would be a mistake to describe functionalism as being the mainstream. I think that today we can, if we speak of methods, is that there's some kind of a toolbox. And in that toolbox, we have different kind of approaches and methods. And I would say that functionalism still is one possible approach, but somehow it has lost its sort of a paradigmatic position. It's not certainly the only one. There are other possibilities. But then again, it still exists. And I know that there are lots of comparatists still relying on so-called functional approach.
Okay. So is it typical also to use comparative law methodology for critique, maybe critiquing your own legal system or, I don't know, legal developments more generally?
Well, it depends what kind of comparatist you are. If you are very theoretical, you have these deep-going questions, this criticism is not possibly part of what you do. But then again, many times comparatists tend to be practical lawyers, or they have, if they're not practical lawyers, they have this practical interest in law. And then many times they look at other systems and see that, okay, our own system is not working well. This particular institution is working poorly, or they have better institutions in, say, American, German, French, or whatever legal system. And then it's really the foreign law point of view, it offers you possibilities to criticize your own system. But there's something that you have to do when you, or be aware of when you use comparative critique. You have to very carefully define that what it is that you criticize and on what basis. You just can't come out and say, look, this is bad because, you know, in the United States, they do it better. It must go further than that. And you can say that, all right, this American model to this solution works better because it is, say, for instance, economically more effective. It produces more sort of a competition, and in that sense, it's more effective. But then you have sort of a particular base on which you rest your sort of a case on and say, okay, economic efficiency, and in that basis, this system is better than the other. So you can use comparative law to critique your own or foreign systems, but you have to very carefully define that what it is that you criticize and what is the base on which you base your criticism on.
Okay, thank you. So how does one then typically conduct comparative legal research? Are there, for example, some concrete steps that are typically taken when you start to conduct research in comparative law?
Well, again, if we say that comparative law is a broad church, there are different kinds of things. It's very difficult to say that this is how you do. But if you read the classical books, say Zweigert and Kurtzor, all these sort of traditional comparative law textbooks, they normally give you some kind of blueprint that you have a research question, then you decide what jurisdictions or countries you study, and then what materials you collect. So it's like a series of steps, but it's very difficult to describe as do it like this way, because many times when you do comparative law research, you realize at some point, but oh, bloody hell, this is wrong. I understood this completely wrong, and you have to go back and reformulate your own research question. So it's back and forth movement. And because of that, it's rather difficult to say that these are the steps you have to do. But in any case, every healthy comparative law research starts from one thing and one thing only: research question. What it is that you're interested in. And from there, you build your choice of countries, your choice of data, and all builds on that particular thing. What is the research question?
Okay. So are there any types of research topics that are better suited for comparative legal research, or are any topics good? For example, there are big differences in how much global or European harmonization there is in place, or how much the topic pertains to international trade or globalization and so forth. So are there any topics which are better suited or not that well suited for comparative legal research?
Well, it depends what it is that you want to do. So if your own research interest is that you are interested in harmonization, then obviously it affects what kind of approach you choose. And I'm not sure if that is easy or better suited for comparative approach, but it's just what you want to achieve. If you want to know why common law does it like this and why French law does it another way, you would probably make different kind of questions. But if you're interested, harmonizing, say why Germans do it like this, and then French do it like this, Scandinavians do it like this. How can I find a common way? How can I find a common solution? It's completely different. So I would say that not so much your research subject is important, rather what kind of interest you have. Do you want to build harmonization? Do you want to criticize? Do you want to learn about deep structures of law? What kind of legal scholarship it is that you're doing? And that has much more important role for your sort of what kind of comparatist you're going to be. But then again, obviously, there's this practical point of view there that if you find lots of materials from one country, it makes sense to go there and study that instead. If you don't find much materials in another country, or the materials in another country is behind a linguistic barrier. It's also a practical question. Where do I get sources from? What kind of data I can collect? Okay,
that's a reasonable advice. On the other hand, could that lead to some kind of overemphasis on English language and maybe United States and UK because you have lots of materials?
It certainly does, because English is sort of a boon and bane of comparative law. The good thing is that we can use same language, we can communicate and understand. But the problem is then that the Anglo-American ideas about law, how to study law, what is law, what is not law. It somehow penetrates other forms of legal research. And I've always underlined the importance of linguistic skills in comparative law. But then again, the problem with certain kind of comparative law scholarship is that it just tends to pile up different kind of demands, that you have to know this, you have to know this, you have to know this and this and this, and in the end you end up having too many demands. But I think it would be fair to say that American law in particular has somehow had perhaps overly great impact on how we understand law, but also how we do comparative legal research. And a particular problem with Americans is that many times they tend to be monoglots. They speak or read only one language, and that certainly narrows down. If you can't read French or German or other languages, then your sort of a scholarly view is automatically somehow narrowed down, and that is a good thing. But then again, I'm not sure if we can fully avoid that, because most of the material is in English. That's just the world in which we live in.
So you don't encourage using Google Translate for doing comparative law?
Well, it depends what you want to find out. If you're going to make detailed analysis of foreign law, then obviously Google Translate is a very bad idea indeed. But if you just want to have overall understanding what's going on there, what kind of things their legislation or case law handles, Google Translate can be helpful. Mm-hmm. Somehow you can narrow down what it is that you're interested in, but you can't fully rely on that, in particular if you want to go to deeper level. But I wouldn't rule it out. It's a tool.
Okay. So what then is the main interest usually? Is it similarities or differences in law, or maybe both? And should one have a kind of a preconception already when you start the research, whether you want to concentrate on either?
Well, that is a classical question. And I think that much of the classical scholarship on comparative law somehow discusses that. And there are different views. I suppose that in 20th century, the paradigm, if we can call it that, was that you should concentrate on similarities. Zweigert and Kurtz's school obviously said that focus on similarities. Then in late 1990s, you have people like Pierre Legrand coming out and saying that, no, this is complete madness. You have to focus instead on differences. And that gives sort of a really life to real ambitious comparative study of law. But I think that we can find a middle way, in a sense that it's sometimes difficult to really know beforehand what it is you're going to find. If you study, say, 2 or 3 systems, do I find similarities or do I find differences? And it should not be so that you sort of beforehand decide that this is what I'm going to find, because it narrows down your own vision. But on the other hand, as you mentioned, sometimes it is useful to decide beforehand what it is that you're interested in. And if you are someone who works for harmonization of law, then I don't think that it makes much sense to focus on differences. Mm. Of course, it's useful to know that they are there. But if your own focus is to harmonize and create something that is harmonized, then I would not concentrate on differences. So again, the interest of knowledge is important. What it is that you want to do, what is your particular interest in doing comparison? Only then you can decide that what's important and what's not important for your particular study.
Okay, so that sounds liberating, that there are different ways of doing comparative law legitimately with different objectives and research interests. But can you identify any typical pitfalls in comparative legal research? So if there is a failure somehow, so what are the typical, you already discussed the language question, but any other?
Well, I think there are 2 rather typical and unfortunate cases. One has to do with the fact that we find sort of foreign eccentric. You study country and you find one author is writing much about the subject, and you have articles and books, and you have understanding that this is important scholar or an expert. And then you base your own writing on those publications. But later you find out that others come and say, you should not cite this person. He's completely bonkers, or somehow outdated or terribly wrong. And that is one lesson. You can't really rely on narrow sort of a source base. You have to look a bit broader. I've seen that happen a few times, and people are amazed. They say, well, this is a professor and former Superior Court judge. Of course he or she knows it. And then, they tell you that no, he's absolutely, or completely outdated. That can happen. And the other one is that I call this the domestic paradox. It is that when you study your own law and then say a couple of other systems, you have your own country A, then other countries B and C. And then you make a common question to all of those systems, same question to all of those systems. And then you present your study in your own country. An expert in your own country may come and tell you that, what are you doing? These are not relevant questions to make. You know that in our legal doctrinal research, these and these and these are the relevant questions. Then you find yourself explaining that, yes, I know that, but this is comparative study, and I have to make similar questions to other systems. And if I would make questions based on my own system, they would not work in the system B and C. So somehow you find yourself explaining to your own countrymen that why I'm making these weird kind of questions. And that is something that comparative approach sometimes, it's a position that comparison forces you into.
Yes, thank you.
Those are practical difficulties. I've seen both in reality, not just making them up.
Okay. So would you actually then also recommend consulting somebody from the jurisdiction when it comes to using sources, so some kind of a reality check?
Yes, that would be very useful. In particular, if that is a system that you don't know that well. If you know the system well, say if you're a Finnish person and you know rather much about Swedish law, perhaps that is not needed then if you read Swedish fluently and you know the system. But if it's very sort of a culturally distant, it would be very dangerous not to contact someone and ask these questions. But also, I think it has to do with the fact that how you use your sources. Lawyers are normally trained to rely on primary sources. We tell to our students that no, don't cite this author, cite directly legislation or Supreme Court cases. They are much more important in the sources of law, in the doctrine of sources of law. But in comparative law, it's different. Many times it does not make sense to start from legislation or case law because you don't really understand what's going on there, and you may end up making wrong sort of conclusions. I would rather start from legal literature, doctrinal literature that explains the interpretations and gives you sort of a epistemological basis, which helps you to understand right what is in legislation or how you should read the case law.
Okay, thanks. Well, sometimes people use comparative materials in a kind of a haphazard way, or where it is convenient maybe to refer to a foreign law or foreign case. So some kind of asystematic use of foreign legal materials. Is it heretic in your opinion from the perspective of a comparative lawyer, or is it something that would learn also maybe from the comparative method somehow?
I think that the classical reply would have been that that's not comparative law. But I'm not sure that makes much sense, because if you have particular research question and it benefits you somehow to use foreign legislation, foreign cases, or foreign legal literature, then I don't see no sort of obstacles. Why would you not do that if it makes sense? But then again, you have to think what it is that you do. And I think it would be a mistake to say that this is what I do is comparative law. Mm-hmm. Because then you invoke all kind of weird comparative law scholars who could come and say that, no, this is not real comparative law. So it comes back to the research question. If it's useful to use foreign law, why not do that? If it's useful to use foreign legal literature, why not do that? Then again, what you call it, it may be issue here. Do you call it comparative law, or is it just benefiting from foreign law? If there's no comparison, it's not comparative. But I don't think it makes sense for a comparatist to come and say that that's bad. Don't do it like that. That's not real comparative law. Of course, it's not real comparative law, because if it's not even meant to be that, so what's the point in the whole discussion? The real question is it useful for you at your own research? Is it beneficial? That is the key question there.
That's relaxing to hear, because I must admit that I have done the same myself, but I have not called it comparative law. Well, maybe a related question, also in many research projects, comparative law, comparative materials are used as a kind of a subsidiary methodology, together maybe with law and economics, or dogmatic legal research, or maybe some socio-legal approach. So how does comparative law methodology fit with these other perspectives or research methodologies?
I think there's some kind of a paradox there. The paradox is this, that in order to do good comparative law study, you have to somehow open the context of law. And you can't do that from the point of view of legal doctrine only. You need historical, sort of economical, linguistic, political information in order to be able to put law in context. So the comparative law endeavor in itself calls for some kind of interdisciplinary approaches. But then again, when you try to do it, it's really difficult. And you find out that, economists are speaking different language, or people who do political science don't understand how you study constitutional law, or all sorts of problems are there. But I'd say that it's much more difficult to fully avoid these other fields if you do comparative law. And if you narrow yourself down to do only some kind of doctrinal comparative law, I'm not sure that is really a wise thing to do anymore. But also, at the same time, we have to recognize that there are lots of differences there. And the whole idea of putting different fields together, it's difficult. We always find legal scholars explaining to others that no, you can't do that because that's not relevant. That's not legally relevant question. And, then social scientists and economists are looking at us and say, what do you mean? What's the problem there? And somehow this whole interaction, even though it's needed, and it's really important, it's in practice, it's very, very difficult thing to do. So there's this paradox of must do it, but then again, when you do it in practice, it's not going to be like a walk in the park.
Yes, that's a very good point. So let's move to intellectual property law specific questions. So IP law or intellectual property law is a relatively new area of law. So maybe from the Middle Ages, so not that old or not that new, but in any case, and there has been quite intensive international harmonization since the end of the 19th century already. We have the Paris and the Berne conventions, for example, from that time already, and international measures have intensified since the end of the 20th century, for example, with the WTO's TRIPS agreement and different bilateral intellectual property treaties and so forth. And it's a very globally operating area. How does this background affect comparative law research?
Well, I think that it somehow automatically narrows down what it is that you can do. But that's not a bad thing as such. If you forget the idea that there's only one way of doing comparative law, if you abandon that idea, which you should do, then again, the question is it beneficial? And of course, if you try to harmonize, if you try to have this global sort of normativities there, comparative law is a tool. You can see that there are similarities. This many countries do it like this, then you can harmonize, you can go forward, or you can show that there are holes there, or gaps in the system, and you can start filling those gaps with sort of a comparative law or comparative law based arguments or findings. And I think that's a very practical thing. But then again, at some point you may find that it's not enough, or there are difficulties, and I'm not sure that you can stay in that technical, that narrow way of doing comparative law, because sometimes there are difficulties there. And in order to understand the difficulties that are there, you need to know more about, say, legal, cultural, or context of law, because you may find that even if you have same rules, same identical or unified rules there, you can see that countries apply them differently. There are still differences there. And then you make this question, why? It's the same rule and same materials, and still they do it differently.
Yes.
And then in order to understand that and to explain, you have to go deeper. You can't go on the black letter law. You have to make different kind of questions of, okay, what kind of legal culture they have there? What's really going on there? And sometimes even the technical interest of knowledge may lead to this cultural, contextual, comparative law. So it's not just on-off question. It much depends that what you find in practice, what you want to do, what kind of difficulties you have there. But this is all because of the flexibility. You can't beforehand say that comparative law is this and only this, and then you follow that particular path. It must be flexible. It must somehow be able to react what you find there. And in order to be able to react, you have to have this methodological toolbox in which you have different tools: functional, cultural, linguistic, law and economics, law and society, all sorts of approaches are there. And that's how I see it. You have to have this methodological toolbox, not this narrow understanding that this is the right way of doing it. That doesn't work, because world of law is complicated. And sometimes you just don't know beforehand what kind of difficulties you're going to face.
Thanks. Well, then in Europe, there has also been a lot of harmonization and even unification with EU regulations. And quite often you find researchers comparing the EU approach. So what is, for example, the approach of the European Court of Justice to EU member states approaches and their legislation and also case law. So can you, for example, then validly compare the EU level to individual EU member states, or are they too different for legal comparison in that sense? Or what should be taken into account, at least if you try to do it?
Well, I think that EU law is kind of a special case. It is really the EU law in itself, because it's not international law, it's not national law, it's something that is sort of a sui generis nature, as they say. And I think that makes it different, because technically EU law is also national law. You can't really tell EU law and national law apart. I know that there are legal scholars who want to do that, but I don't think that's possible, because we are under the same umbrella.
Yes.
But of course, why not do a comparison there if it's useful? If you're interested looking at this EU approach, then you see that different member states or one member state uses different approach. Obviously, you can compare them, but the question is then what it is that you want to find out. Why do you do this comparison? Just to point out that they do it wrong, or that they do it better, or in Czech does this better than Sweden, because it all boils down to the question that what it is that you're interested in. If you do EU law research and want to find out why there are differences there, then why not compare? Or if you are sort of a more practical EU lawyer and you think that they are doing it wrong, by comparison you reveal that there are mistakes there, and follow what the EU court is saying. It really comes back to what is your particular interest of knowledge. But as a general rule, I'd say there's nothing that stops it. There's no comparative law doctrine or theory that says that, no, you can't do it. If it's useful, why not use it then? Although EU law is, as I mentioned at the beginning of this bit rambling, perhaps, reply, is that it is a legal system. And in many cases, it's very difficult really to distinguish between EU law and national law, because they are really somehow united in many questions. Although you may have different replies from Poland, for instance, but let's not go there.
Yes. So in case of unified EU law, when we have, for example, EU regulations that should totally harmonize or unify the legal approaches, so still maybe the case law might be different in different member states. Does it make any sense to compare, for example, case law and focus only on, let's say, how they apply the law?
Well, it makes sense in the sense that there's a classical distinction between law in books and law in action. And sometimes if you see that law in books is similar, or it should be the same, but you realize that law in action is different, then obviously that calls for some kind of a research of why that is the case, why in those member states they do it like that. I think it makes perfect sense, but that is obviously a integrated interest of knowledge going on there. You want to understand because it's a problem there, and you want to find the reasons why the problem exists. And then the comparative study helps you to understand what are the problems and possibly gives you a hint as what to do in order to resolve these issues.
Okay. So quite often United States IP law is compared to European Union intellectual property law or the law of the EU member states, because I think the United States is often seen to kind of lead the way with intellectual property legislation that the EU and the member states might then follow. And of course, there is also an abundance of case law and scholarly discussions available. But then again, it could be that some other jurisdictions could be perhaps less explored and could be more interesting. So how to select actually the jurisdictions for the comparison, and also how many jurisdictions you would recommend taking, for example, to a doctoral thesis?
Well, this is a very difficult question. Obviously, in many cases, it makes sense to study the US law because it is important. It has impact on the whole world. It would be childish to deny that impact. But then again, on the other hand, as you mentioned, it is problematic if you just focus on the US law because there are other systems and other things are going on the globe. So, but that's also a question of language. What languages you can use, what languages you can read. If you can't read Spanish or French, well, obviously that limits what you can do. But that's not that bad because in many cases, I think the US law is really important. It has been transported or transplanted to other countries. So it has really, in many areas of law, this global impact. But then about the question, how many jurisdictions? It really is a question of how deep you want to go, how intimate knowledge you want to have of those systems. If you want to study very deep level, if you want to understand the legal, historical, legal, cultural level, you can't have many countries. It's impossible. Perhaps two may be enough if you want to. If you study Chinese and say American law, then you have to read Chinese in order to be able to do that. But you can go deep. You can go to legal history. You can do all sorts of things. But then if you take 20 countries, obviously you can't go that deep. So it's a critical question. What kind of things are of interest for you? What kind of research question you have? If your question is sort of a quantitative in the sense that this is a question, how these 25 countries have answered to this particular question, then you don't need to go very deep. And you probably can have reliable English translation from those 25 countries. And it does work like that. But if you make sort of a deep, difficult question that how does it work? Why have they assumed this kind of approach? And you need to go much deeper. Then obviously the depth of your question somehow reflects on the number of countries that you can have.
Okay.
So it's also a technical issue.
Yes.
in this sense.
So you could, in some cases, maybe do systematic content analysis, maybe even use some software for it, for analyzing legislation or case law? Is that possible?
Yes,
also?
yes, that is. I think that one of the new sort of arising areas in comparative law is computational legal studies.
Okay.
And that's really area they are developing methods and approaches based on the sheer fact that we have data. It's just that lawyers and legal scholars need to learn to somehow analyze that data, because there's a gap between our sort of a innate legal doctrinal approach and then this sort of a quantitative approaches. And that is a problem at this moment, because lawyers are not very good with sort of these quantitative or computational methods. But I think that's slowly changing, because applications are developing and techniques are developing, and it becomes easier even for legal scholars to learn and use these kind of approaches.
Yeah, that's good to hear. Well, then there are also some supranational institutions. For example, in Europe, it's not part of the European Union, but we have, for example, the European Patent Convention, 39 member states, and it has a supranational office, the European Patent Office, and the European Patent Office, for example, has its boards of appeals, which handle different kind of complaints. And they produce a lot of case law, actually, and also different types of guidelines. So are there any specific issues if this type of case law is utilized? Because then you don't have a similar legal culture and history, for example, when compared to, let's say, US law or UK law or whatever.
I think this has been a particular problem for comparative law, because comparative law was somehow built on the sort of a Westphalian tradition of states or public international law actors. And slowly, it seems to me that comparative legal scholars are learning away from that world. And one particular outcome of this is that the notion of legal system is somehow being abandoned by many, because if you use the notion of legal system, it somehow seems to be connected with, say, nation states, and things that you mentioned are different. They're not nation states, and the norms that they produce are different. They are not like nation-based legal norms, or they are different kind of things. And one way to go around this question is that some comparatists are very much interested in legal pluralism and stuff like that, and we have started to use the notion of normativities, instead of legal systems.
Okay.
But this is some kind of an outcome or a result of the fact that this old state-based system doesn't seem to be working. And we have to have somehow more flexible understanding of that there are different kind of norms are being produced there, and they are being produced by non-state actors. There can be transnational corporations or organizations, and still it would make sense to compare those.
Yes.
And that is some kind of transformation that I think is going on in comparative law at this very moment. Even though if you read the literature, I'd say that 95% of literature is still based on this old Westphalian state-based structure. And this is a challenge for comparative law, but I think some of us are trying to learn it. One good example could be, I don't know if you know, rather famous comparatist works in EU Institute these days, Matthias Sims.
Yes.
His book, Comparative Law, I think he tries to squeeze in there these new approaches, quantitative approaches, computational approaches, and combine all that with more traditional understanding of comparative law. And it's interesting to see what comes out. Yes. Because in principle, why could you not compare these kind of normativities that you mentioned? They are not just state legal systems, but yet they are normativities.
Yes.
There is structure, there are rules. Why not compare?
Yeah. Yes. I think the same could be done with the WTO and maybe European Convention of Human Rights and similar institutions. They also produce case law and other materials. So it's very, very interesting to hear about it. And maybe I think in the intellectual property field, there have been quite many studies where, for example, the case law from the European Patent Office has been compared with national patent offices. But I think on the other hand, it has not been theorized. People have just been doing it intuitively.
Yeah. But that's a good point, because many times I think it has been problem for comparative law as a field that it has somehow made itself sound impossible. And I mean that lots of demands. You have to know language, you have to do this and that, and if you do it wrong, it's not comparative. And that is something that we have to learn away from, because comparison and comparative methods can be very useful for all sorts of research questions. And we should not limit too much or be too strict about, is it right kind of comparison or wrong kind of comparison? Hell, if it's useful, then use it. If it makes sense, then use it. If it's beneficial, use it.
Thanks. Well, intellectual property law, we also maybe discussed this a bit, but it interacts very intensively, for example, with the development of the economy and different technology and the society, information society overall. So, for example, when there come new technologies, now we are talking about artificial intelligence, then immediately IP law scholars start thinking, what does it mean for IP law? What does it mean for interpretations? Do we need new rules and so forth? So does this maybe a specific feature of intellectual property law? Does it affect legal comparative work in your understanding?
No, I don't think that it will. It's just that the issue here again is that if you understand comparative study of law in a broad manner,
yes,
so that it offers you different kind of tools to do legal studies, legal research, then it helps you. And that is the way how I want to see and define and understand comparative law or comparative legal studies. But if you believe the old school, old paradigm, then it doesn't go like that. There are lots of warnings there. Don't do it like this. But that is the old world, and I want us to learn away from that. So IP law, any new field of law, if it benefits from these
yes,
comparisons, again, the issue is really, what is your research question? Does it make
yes,
sense for you to use
right,
various comparisons? That is the key issue there.
okay. Quite often these technological developments, they are global in nature. So then you could, for example, expect that there might be some reactions from the legislature or the courts to a certain specific development. So does this maybe help legal comparison if it is more easy then to identify, for example, what has been the reaction of the EU or some EU member states or the US or Australia, let's say, to artificial intelligence in patent law?
Yes, it does. But again, I think that the scale is a problem here, because as you mentioned, these are global developments. And if you think that there's only one researcher, a comparatist, doing solo research, it's impossible to take all these things into
yes,
account. And I think that is one of the new challenges for all kinds of legal research, to formulate research groups,
yeah,
with different kind of skills, and the
yes,
skill sets need to somehow fit for the global level. Because the old idea was that some kind of a genius comparatist in box stays there and knows all the languages and writes books. That is not today. Today we need to work together with economists or data science experts, and somehow this interaction should produce research groups, and the research groups are much more effective tackling or addressing these global issues on new fields of law, new issues, new normativities. I think that is one challenge, but it's also a challenge for legal scholars, because we have been always doing, mostly work alone in our own offices, coming out every fourth year with a new book, bang, and then going back in the box. That is really, you can still do that. I'm not saying that you can still do that, but these new questions of IP law, globalization law, I think it requires much more sort of a broader skill set than just staying in your own box and learning everything about everything in one particular issue.
okay,
Which you can still do that.
yes,
But these globalized problems
yes,
and the old method, I don't think that they meet each other very well.
that's a good point. In IP law area, maybe you find quite often edited books on a certain, let's say, technological development, and then contributions from different jurisdictions describing their own law and reactions. But quite often, actually, the comparative element might be lacking in the end. So maybe
that is a very old problem.
Yes.
You have a book called Comparative X Law, and you say, oh, they compare it. Then you take the book, read very short introduction, perhaps no conclusions at all, and then you see the chapters, one chapter from that country, another from another country, and then you start to think that, okay, this is interesting collection of different legal systems, but where is the comparison?
Yes, maybe the reader can do it then in his head, in his or her.
But that's not the point. You be able to do that in the book. To point out that these are differences, these are similarities, and perhaps what kind of conclusions you should be drawing based on those similarities and differences that you find.
Okay. So maybe one, I don't know how specific feature this is for intellectual property law, but it's really a heavily lobbied area. And formerly it was mostly the movie studios and music industry and so forth. But now we also have corporations like Google, Meta, Facebook, and so forth, lobbying really heavily for the legislation. Is this something that comparative law could maybe aid studying maybe this, or is the strong lobbying something that could be or should be taken into account in comparative legal research?
I think there are sort of 2 points here. One is that if you are aware that this kind of lobbying goes on as it does, then it does not make sense to narrow it down to black letter law, because if you know that certain industry has its own view and manages to push its own view through into legislation, and you are aware of that, it makes no sense to narrow down, okay, I'm just looking what the legislation says or what the courts are saying about it. You have to have some kind of contextual, a broader approach. That is the general view. Then the second point or comment on this is that if you study differences and similarities and then try to understand and explain them, in that part, it's very important to be aware of this lobbying. And you can say that, okay, in that country or in that jurisdiction, they've chosen this road or this solution because they have this sort of a strong industry or strong sort of a interest group that managed to, to push through their own view on it. And both of those are somehow speaking for broader view of comparative law, just opening up and seeing what is the context of law, why it is as it is, whose views have been somehow legislated, and who's had the power to have their own views to put in that particular form, in form of norms.
Okay, thank you. I think recently in intellectual property law, there has been quite a lot of discussion also about private regulation or semi-private regulation, maybe because the public authorities might be involved in some respects. At least we have, for example, different internet platforms. I already mentioned Google / Alphabet and Facebook / Meta, and also other big operators. They might, for example, conclude different types of agreements with global reach for the supervision and enforcement of IP rights in the internet. And these materials might be, for example, available, but sometimes they are not. But they are kind of really powerful rules. So are these types of rules beyond the reach of comparative law, or could they also be somehow included in the comparisons or the analysis?
My reply will be very short. They are out of the reach of old-fashioned comparative law, but they should not be out of the reach of modern, today, comparative study of law. They should automatically be taken in and be studied by comparative methods. I think that makes sense. As I mentioned previously, these normativities, you speak now of normativities, private companies and these private rules, private ordering. That is something that should be compared. It does not make sense in today's world only to stay within the old state boundaries. It is not sufficient, not anymore, if it ever was.
Okay. So I think we are approaching the end of the interview. Do you have any tips for doctoral or master students regarding comparative legal approaches? So some final wisdoms for them.
Perhaps something that I've tried to underline throughout the whole discussion is that it all starts from the research question. You should not ask yourself that what kind of comparison I'm going to do. You should rather ask that, does my research question require me to use some kind of comparison? And if you find out that you don't need comparison, then don't do it. There's no external reason for you to do it, or somehow, decorate your own study with comparative point of view if you don't need that. But then again, if you find out that the research question that I'm making requires me to compare different systems, then you have to think, okay, what kind of approaches there possibly are? And then you go to legal sort of like comparative law scholarship and try to find out what kind of things there are in the methodological toolbox of modern day comparative study of law.
Okay, thank you very much. Maybe then as a final question, were there any questions that you kind of expected, or any areas you would still like to cover that were not discussed?
We always discuss about functionalism and similarities and differences. That is, what I should stress. But I think that if there's something I could say here in the end is that there's a famous phrase by J.F. Kennedy, and that about, ask not what you can do for country, ask not what your country can do for you, ask what you can do for your country. I think you can paraphrase that in comparative law context and say this is about method. Do not ask what comparative method can do for you. Ask what you can do for your comparative method.
Thank you. I think this is a good point to end the discussion. So I'm very thankful for you, Professor Jaakko Husa, for this interview. It was very illuminating for me, and I guess also for those listening to this video. And there will also be some recommended literature in the platform. So please also read the articles there. Thank you so much.
Thank you.